Hello, and welcome to another episode of Virtual Legality. I'm your host, Richard Hoeg, managing member of the Hoeg Law business law firm of Northville, Michigan. And today we're diving once again into the story about payment processors, the financial infrastructure systems, and video games, insofar as they are preventing video game purveyors like Steam and itch.io from selling adult-facing content that is otherwise legal in the jurisdictions that we're talking about, in particularity, the United States. And in also particularity, we're going to talk about an executive order today that was signed by President Trump that has been described, as you can see on your screen right now, by some as essentially destroying the payment processors and what it is that they've tried to do by encouraging Steam and itch.io to get rid of these products and services. Now, as lawyers are wont to do, I'm here in Virtual Legality to pour a bit of cold water on this particular notion that the payment processors, the financial industry on the whole, is somehow screwed, as this particular thumbnail puts it, or destroyed by the notion of an executive order signed by President Trump, or at least this particular executive order that we're about to read as part of this video. Now, I also wanted to bring up another tweet that I saw from a commenter called Vara. And again, if you're in Virtual Legality for the first time here, I don't endorse any particular readings of anything that I'm looking at when I talk about them in this space, but there are folks on Twitter, on social media, that are making commentary like this one, and I found it particularly useful to dive into, that I think are a little bit wrong-headed. Not that there's anything wrong with taking a crack at evaluating these things on your own. I highly recommend it for anybody that's watching or listening to this show. But in this particular case, we can take what Vara says here and we can analyze it as part of this video and see how she misses the mark a little bit. As she puts it, this executive order came down today, and it clearly states banking services can't be denied because of protections provided by the Constitution of the United States. That seems to be implying the First Amendment freedom of expression issues that we've talked about as part of this series. It mentions companies have 180 days to remove any provisions from their terms of service that mention reputational damage to themselves due to the fact that they must provide all lawful citizens with banking services. Now, that's a misunderstanding of what this executive order is going to do. We're going to dive into that as part of this video. Companies like Visa, MasterCard can no longer deny payment for something that, in their opinion, lacks artistic value, but is legal in the U.S. And that goes too far with what this executive order says as well, which Valve had pointed to their rule that outlines the sales of products or services that are, quote-unquote, patently offensive and lack serious artistic value or any other material that the corporation deems unacceptable to sell in connection with their mark, their trademark, as a violation of the rule that they put forth. And that's a reference to the MasterCard rule we saw cited by Steam and that we discussed in the prior video in this series. Ultimately, creators can't have funding sources ripped away from them over political opinions deemed damaging. And so I wanted to highlight this commentary because this is the same kind of comments that I saw online so often with respect to this story, and I think it goes too far. It's incorrect in important ways that I think lead people to believe that, one, this fight is over when it very much isn't. That if you care about these things, if you care about Visa, MasterCard, PayPal, or whomever forcing Steam and itch.io to not sell what those services want to sell to you and which are legal in the jurisdictions we're talking about, then you have a continuing fight to engage in on this particular topic. But also, I just wanted to talk about what an executive order actually is, what it isn't, and so we can better understand what it is that President Trump or any other president in the United States or any other jurisdiction is actually capable of doing on this score with a method like an executive order. So on that note, please hang in there. We're going to get into the weeds on this. But before we do, I wanted to mention that this channel is supported by viewers and listeners like you through Patreon, through memberships and super chats and other things that you can do to tell Google that you are enjoying this kind of commentary. Also, among those things are leaving comments. This particular topic tends to rub the algorithms of the world the wrong way because we're going to say words that the algorithms don't like when we talk about these things. And as I said in my prior video, we're not going to restrict ourselves from saying those words. I find it anathema to talking about censorship by only censoring myself to using words that the algorithm approves of. So please do leave comments, leave likes, leave dislikes, whatever it is that actually touches Google and YouTube's buttons. It really appreciates that. It seems to let these videos be seen farther and wider than they would be without that process. So if you're interested in these types of conversations and you find them useful, please do leave a comment. I also try to read those as much as I can and get to answers of questions that people have in those comments as well. So please do consider that. Now, as I said, we're going to get into the weeds here. And as I promised, we're going to get into the weeds on a legal basis, as this is a legal-facing YouTube channel. So the first thing we need to understand is what an executive order is. So I've highlighted here the three branches of the U.S. federal government. I assume for most United States listeners and viewers that you got some version of this in elementary school, but we have a lot of international viewers and listeners on this channel, and I want to make sure that we're clear on what is and isn't happening here. So I've put 3 boxes on your screen, one labeled judicial, one labeled executive, and one labeled legislative, to show the 3 branches of the U.S. government. Now, we call these co-equal insofar as they have checks and balances and things that they can do and can't do and fight against each other in certain ways. They aren't necessarily equal in every instance, but it is a useful kind of rubric to think about, that the judicial, executive, and legislative can't really do everything that the U.S. federal government wants to do on any given issue. And to underscore that a little bit more, I've highlighted what it is that we're talking about here and what it is that they do and don't do. So on your board right now, you see executive branch in blue. That's the branch that is going to be issuing an executive order. That's the president of the United States. And I've highlighted here that his job is enforcer. He enforces the laws, and he sets enforcement priorities through things like executive orders. He tells the executive branch what he wants to have happen in the enforcement of laws. But he doesn't write those laws. Who writes the laws? The legislative branch writes those laws. They are the rules maker. They are the ones putting forth what the public policy of the United States actually is. And you'll hear newsmakers talk about the fact that the president sets public policy. That's true insofar as he asks the legislature to do things for him. It isn't true when we're talking about executive orders like the one we're about to talk about today. The legislative are the ones that evaluate what the problems of the country are, determine what the public policy of the country should be, and writes laws around that public policy. The executive then goes to enforce those laws as written by the legislative, but they are not the final arbiter of whether a law has been broken. They go to enforce them by maybe bringing an action in court, and then the judicial branch actually interprets what the law says and decides the cases and controversies before it. So yes, co-equal branches doing different things, but what's important about this story is that an executive order is not a law. It is a set of enforcement priorities that only govern the executive branch itself. So your first takeaway when you're talking about this issue with others, online or otherwise, is that executive orders govern the executive branch. The executive branch is huge. It's thousands of people, agencies all over the place. We've talked about a lot of them here in Virtual Legality. An executive order says, all right, agency, I want you to think about this issue this way. I want you to enforce it in this manner. But an executive order does not control the citizenry. It does not control the judiciary. The executive branch can say, this is what I think this law says, and this is how I want you to enforce it. The agencies can take that under advisement and do what the president asks. That's what they're supposed to do in the executive branch. But that doesn't control what the court might say the law actually says. It's just one person's evaluation of what it says, and they don't have the power, they don't have the authority to evaluate that for all the citizens of the country. So we'll talk about that as we go on in this video, but the judiciary is going to have an important role to play in whether or not the executive order we're about to read can even take effect to the extent that the president seems to be advocating it to. So as we dive in here, in the Guaranteeing Fair Banking for All Americans executive order issued on August 7th, 2025, we'll see certain areas in which the presidency and the executive branch on the whole maybe try to steal a base, maybe go a step further than an executive order really allows them to do. And the courts are not always going to look so kindly upon that. That's our first kind of commentary. Executive orders cannot control the citizenry. They cannot actually order MasterCard or Visa or PayPal or anyone else to do anything. What they can do is tell the people that already work in the executive branch, the agencies and whatnot, what it is that the president wants to see them do. So first we start out with what we might call recitals in a legal document here, where we establish what the problem is. We talk about what issue we're trying to address with this executive order. Section 1, purpose. Financial institutions have engaged in unacceptable practices to restrict law-abiding individuals and businesses' access to financial services on the basis of political or religious beliefs or lawful business activities. So first and foremost, we see here that the purpose is to address financial institutions engaging in what the president deems to be unacceptable practices. Financial institutions are not what we're talking about necessarily with respect to the video game situation. We're talking more about the processors, the people that allow the money to move between banks rather than the banks themselves, the financial institutions on the whole. We also note in this first sentence that the focus appears to be on political or religious beliefs, even though lawful business activities are also included in the second category. So we already have a concern that this isn't aimed directly at what we'd want it to be aimed at, which I will spoiler alert for you here, it is not. Some financial institutions participated in government-directed surveillance programs targeting persons participating in activities and causes commonly associated with conservatism and the political right following the events that occurred at or near the United States Capitol on January 6, 2021. Here again, we say, all right, so this executive order is really concerned about debanking, right? It's really concerned, as the headline says, making banking fair for all Americans, but it's really concerned about that from the concept that the banks, the financial institutions of the country, were erroneously surveilling and otherwise harming people that were associated with conservatism and the political right. Now, I don't know how you choose to characterize Steam and itch.io getting rid of adult games on their services, but I don't think that that is a step taken by Steam or itch to specifically advocate for conservatism or the political right. In fact, the most common refrain in terms of arguing against these particular censoring activities is that conservatives and the political right are the ones that Collective Shout, the advocacy group that has moved for some of these actions to take place. And so, if anything, Steam and itch trying to fight the payment processors on this are advocating for a more liberal kind of concept in terms of what they should be allowed to sell. So if this executive order were limited only to telling banks that they can't harm conservatives and the political right, we would look at this and say that's a really difficult case to make for Steam and itch against Visa, MasterCard, PayPal, or whomever. But that's not all this says, so we can continue to read on. The federal government suggested that such institutions flag individuals who made transactions related to companies like Cabela's and Bass Pro Shop, or who made peer-to-peer payments that involved terms like Trump or MAGA, even though there was no specific evidence tying those individuals to criminal conduct. So here we see that the issue that the president poses in this purpose section is that banks were debanking people for saying nice things about right-leaning politicians or politics, and also that the federal government was taking an extra step and suggesting to banks that they debank folks that shopped at places that might otherwise reflect conservative or right-leaning political views. And I think it's easy enough to look at this situation and say, all right, if that is in fact the case, if that is in fact what happened, then this seems appropriate to say, banks, you shouldn't be doing that. We already talked about payment processors being essentially infrastructural, common carrier type entities. Banks, certainly in 2025, in the 21st century on the whole, digital banking and the economy on a global basis are that same kind of infrastructure piece of the economy. And so this all makes sense insofar as it is written here. We don't have the kind of evidence to suggest this actually happened in the way it is stated here in the purpose section, but that's not what an executive order does. So we press on. Bank regulators have used supervisory scrutiny and other influence over regulated banks to direct or otherwise encourage politicized or unlawful debanking activities. Quote-unquote Operation Choke Point, for example, was a well-documented and systemic means by which federal regulators pushed banks to minimize their involvement with individuals and companies engaged in lawful activities and industries disfavored by regulators based on factors other than individualized, objective, risk-based standards. So here they're saying, okay, the federal government in the past had an operation, quote-unquote Operation Choke Point, that said, we're going to push you to debank folks that we don't find terribly helpful to our political cause, and that the banks did that other than for reasons based on risk. Now, I highlighted in this discussion other than individualized, objective, risk-based standards because this is the kind of concept that probably needs a defined term, probably would need in a law a specific section talking about what we mean by this term. We can understand it intuitively as something like, all right, bank, you can look at somebody's income level, you can look at what they do with their money, and you can say, I don't want to make this loan, I don't want to allow this banking service because I feel like you are more likely to default on your loan or your checking account or what have you. And if we can make that kind of actuarial argument, then we can otherwise not work with you, and we have to be able to do that because otherwise we can't stay in business. But just saying you shop at Cabela's is not something that we think would otherwise indicate a higher level of risk for loans or checking accounts or otherwise. And so if you were doing this on some other basis, then we've got a problem. The issue with this from the perspective of the story we're talking about is that the MasterCard rule we mentioned in the prior video essentially says MasterCard can look at a situation and say, this increases our corporate risk. It can be economic, it can be reputational, it can be any of these things. And if it so increases that risk, we can tell you we might be concerned about this. And as we also talked about in that prior video, MasterCard itself doesn't necessarily have to say anything when its financial partners can be told that this rule exists, and they can put the push down on Steam or itch or anyone else that says MasterCard might have an issue with this. And then Steam adds a rule that says, okay, developers, don't add anything to our service that MasterCard might have an issue with, which is obviously an impossible situation for MasterCard. It's an impossible situation for the devs. It's an impossible situation for Steam. But that's where we exist right now, none of which necessarily speaks to anything that isn't an individualized, objective, risk-based standard. So we already have our first issue with kind of vagueness here, which is to say, all right, if that's the basis you're going to use for your rule, and spoiler again, it is, then we've got an issue with these payment processors or even these banks being able to say, well, look, that is an individualized, objective, risk-based standard. We don't want to work with incest porn video games. We think that increases the likelihood that Steam or its users are going to cause a problem for us, either reputationally or economically. And so that's a legitimate business interest that we have. And so go away, executive order. We're not really concerned about any of this. Continuing, as a result, individuals, their businesses, and their families have been subjected to debanking on the basis of their political affiliations, religious beliefs, or lawful business activities. And you see that last category is what we're talking about, because I don't really believe that the sales of video games on Steam or itch are politically affiliated or religious beliefs, and have suffered frozen payrolls, debt, and crushing interest, and other significant harms to their livelihoods, reputations, and financial well-being. Such practices are incompatible with a free society and the principle that the provision of banking services should be based on material, measurable, and justifiable risks. I.e., again, we don't have a problem with you coming to the conclusion that somebody is a risk to your loan portfolio. You don't want to issue them money. We're not going to mandate that you otherwise loan things to people or otherwise open checking accounts for everybody that walks in your door, even though the federal government does that in certain important respects. They further undermine public trust in banking institutions and their regulators, discriminate against political beliefs and free expression of those beliefs, and weaponize a politicized regulatory state. Policy. It is the policy of the United States that no American should be denied access to financial services because of their constitutionally or statutorily protected beliefs, affiliations, or political views. Now, the first part of that sentence sounds like we're aimed directly at what we're talking about, right? MasterCard, Visa, PayPal, whomever, arguing against Steam and itch being allowed to sell what they are otherwise legally allowed to sell. And that might be its own issue. But again, comes the concept that we highlighted at the top of this, that what we're really concerned about if we are the executive branch of the United States are actions that go against beliefs, affiliations, or political views. It's very difficult for me to imagine Steam or itch arguing that their sales of these games qualify for that, except on the broadest basis of we should have the freedom to sell whatever we want. Banking decisions must instead be made on the basis of individualized, objective, and risk-based analyses. Definitions. The term politicized or unlawful debanking refers to an act by a bank, savings association, credit union, or other financial services provider to directly or indirectly adversely restrict access to or adversely modify the conditions of accounts, loans, or other banking products or financial services of any customer or potential customer on the basis of the customer or potential customer's political or religious beliefs, or on the basis of the customer's or potential customer's lawful business activities that the financial service provider disagrees with or disfavors for political reasons. So a lot to unpack there. Obviously, that's full legalese. We're getting into the law part of this entire conversation. But let's start unpacking. First, we note that what we're really talking about here at the top of this definition are banks, right? This is a debanking executive order. This isn't really about payment processing at all, although the definition is written broadly enough to grab what we're talking about with respect to processing credit card payments into Steam or itch or anyone else, right? We can read this to just point directly at other financial service providers restricting access to financial services and say, yep, that hits what we needed to hit for what we're talking about as part of this conversation. But we have to note, as certainly MasterCard and Visa and anybody else would note in reading this, that this is not aimed at us. This is aimed at banks. This is aimed at debanking. Furthermore, it's aimed specifically at debanking for political or religious beliefs and only really restricts us from doing things that harm people's lawful business activities if we did it because we disfavor those activities for political reasons. Now, it's easy enough to get out there on the streets and argue that what Visa and MasterCard are against here are things that are lewd or things that are something that don't agree with their political affiliations as companies. But it's more difficult to see them disfavoring these things as political reasons from a conservative versus liberal perspective, or anything that we might consider politics outside of the overall everything personal is political kind of concepts, which is not what the law aims at, is not what this language aims at. So are Visa and MasterCard doing this to steam an itch for political reasons? You'd have to make a pretty narrow argument, and certainly Visa and MasterCard would make the opposite argument. They're doing this because of the brand damage they think would happen with respect to their brands if they allowed these things. And if it came down to it, they're doing it because we think that services that provide these types of products to their customers are more likely to default for some reason that we could probably make with the copious amounts of data at our fingertips if we're Visa, MasterCard, PayPal, or anyone else in the financial processing arena. So we've got issues with the definitions there. We do note again that it's just not aimed at what we want it to be aimed at. So when we talk about the commentary that we mentioned at the top of this video, it has to be part of the conversation that this executive order not only just controls the executive branch and not the Visa and MasterCards of the world, but also isn't really aimed at this particular issue. It's aimed at an adjacent issue, which might well be applicable to the issue that we're concerned about when we talk about it in virtual legality. But as it not being aimed directly at it, would be fairly easy for the payment processors in this particular story to skate around. Now, the term federal banking regulators, as stated in this executive order, refers to the Small Business Administration, SBA, and the federal member agencies of the Financial Stability Oversight Council, with supervisory and regulatory authority over banks, saving associations, or credit unions. So looking at this, like we mentioned at the top, executive orders can only control the executive branch. This executive order is aimed at federal banking regulators. It is aimed at telling the SBA and the other federal member agencies that otherwise license the banks in the United States, and I'm going to shorthand this considerably. So if you're a lawyer in the credit industry and you're in the comments, you can let the folks know exactly how much my shortening has missed the message of what it is that federal regulators do in the banking industry. But these are the folks that license banks. If you don't do what they say, if you don't operate in the way that they tell you, then you can lose your ability to perform banking services in the United States. And so they're very important regulators in the country, but they are the only bodies that President Trump has the authority to kind of order around in a manner like this one. Section 4, removing reputation risk and politicized or unlawful debanking. Now, this is the section that we saw the commentator Vara talking about earlier, suggesting, as she did, that it mentions that companies have 180 days to remove any provisions from their terms of service that mention reputational damage to themselves. That's not what's happening in this section. So let's see what is happening. Within 180 days of the date of this order, each appropriate federal banking regulator shall, to the greatest extent permitted by law, remove the use of reputation risk or equivalent concepts that could result in politicized or unlawful debanking, as well as any other considerations that could be used to engage in such debanking from their guidance documents, manuals, and other materials. So what that says is that the people under my purview, if I'm President Trump, will take out of their recommendations for how to comply with our rules and regulations that you can use reputation risk or equivalent concepts in your materials because, according to President Trump and his executive branch here, that allows for too much leeway for you to start debanking people on political grounds. But what he doesn't do, what he can't do, what he doesn't have the authority to do, is tell Visa and MasterCard that they can't have that rule in place. He can tell his regulators to say, that's not a recommendation and maybe we'll penalize you. We'll see that a little bit further on in the executive order. But he can't tell them what to do. They are the citizenry. They are outside his purview in this context. That's why when we have major issues in the United States, when other folks have major issues in their jurisdictions, I always tell you, you can't depend on the executive order process. You have to actually pass laws. This was not that controversial not so long ago, but if you want to fix things on a policy basis in the country of your choice, you actually have to go and get whatever version of the rules that are passed by your representatives in the books, more than you have to get executive orders and kind of policy preferences established by the executive here in the United States. So that's what this actually says. Then we note the parenthetical, which is super important here. We just told you that you should remove all references to reputation risk other than existing regulations or other materials requiring notice and comment rulemaking. Now, notice and comment rulemaking is how rules are made by regulators in the United States to comply with the Administrative Procedures Act that we actually have to post when we're going to do something serious, and we have to take comments from the public And then only after certain timeframes have been passed can those rules go into effect. So those are the important rules. Everything else is just guidance documents, manuals, and other materials in this particular rule. Those aren't that important to how a bank is actually licensed. They are not important to how the country actually operates. They are important insofar as if you're running a bank, you want to comply with the regulator that's breathing down your neck to do various things. But the things that aren't going to change as a part of this executive order are the things that have actually gone through the formal process of notice and comment rulemaking. So we're already talking about a thinner slice of everything than what we would have been talking about without this context. But this is the executive or his lawyers essentially saying you can't actually ask for anything that goes beyond these kinds of opaque, somewhat middle-of-the-road documents described here as guidance, manuals, and other materials. And so you can't take out the real rules. You can only take out the kind of slight, unwritten type rules that these regulators are otherwise using. The federal banking regulators shall also consider rescinding or amending existing regulations consistent with applicable law to eliminate or amend any regulations that could result in politicized or unlawful debanking, and to ensure that any regulated firm's or individual's reputation is considered for regulatory, supervisory, banking, or enforcement purposes solely to the extent necessary to reach a reasonable and apolitical risk-based assessment. So this is the kind of umbrella concept. Look, regulators, you'll also consider rescinding. I'm not actually going to order you to rescind, but you'll consider rescinding anything that you find that might otherwise create this gray area that would allow you to debank on a political basis. Now, that's obviously very broad, but just like every other aspect of this story, the agencies themselves, the federal regulators themselves, are going to have a certain amount of leeway themselves to determine what it is to comply with an order like this one. And certainly this is weak language on its face. The SBA, the Small Business Administration, shall within 60 days of the date of this order give notice to all financial institutions with which it guarantees loans under its lending programs, requiring that each financial institution that is subject to the SBA's jurisdiction and supervision, within 120 days of this order, make reasonable efforts to identify and reinstate any previous clients of the institution or any subsidiaries denied service through politicized or unlawful debanking action in violation of a statutory or regulatory requirement under Section 7A of the Small Business Act, or any requirement in a standard operating procedures manual or policy notice related to a program or function of the Office of Capital Access, with notice of the reinstatement sent to the victim. So, a lot of legalese again. But what this says is that the SBA and all the banks that operate with SBA loans that are guaranteed by the SBA will tell the banks that it's affiliated with that they will make efforts to go and figure out whether they've done any debanking that would violate the concepts here in this executive order. But because the executive order can't set laws, they actually have to point to rules that might have been violated by this debanking. And so they point to Section 7A of the Small Business Act, and they point to operating procedures manuals and policy notices that are, again, in that kind of unwritten rules, not quite rule and comment rulemaking type documentation, and say those are violations. And so you will go and you will fix these things, institutions which we are affiliated with at the SBA. Now, the biggest issue here is, as we've already talked about, the executive branch is not the judiciary. So you can make an executive order and say, all right, we think this is a problem, and we think that debanking in this fashion is illegal in some important way, but you, people that are operating the bank, people that are operating the payment processor, the other financial services companies, might disagree, right? This is actually saying you will go and you will identify anybody that you debanked in violation of these rules. Surely you didn't think that you were doing it in violation of the rules when you did it only a few years ago. And part of the overall recitals portion of this document suggested that the government itself was encouraging banks to do this thing. So you didn't feel it then. You probably don't feel it now. If you don't feel like you're in violation for whatever it is that you did in the past, then this doesn't do anything at all, right? The SBA says, all right, go flag for us the people that you did this to. And you say, well, we're not bad people here at Bank X. We didn't do this at all. There was no violations of Section 7A of the Small Business Act. That's the loan guarantee program. We don't know exactly what's in the rest of the operating procedures manual or policy notice, but probably very similar. And so we don't think we violated any rules. So thank you, SBA, for contacting us with this, but we don't think we have to tell you about any victims, as you so nicely frame it in this document. In addition, the SBA will say within 120 days of the date of this order, you have to identify all potential clients denied access to financial services through a politicized or unlawful debanking action in violation of the things we just talked about. And within 120 days of the date of this order, you identify all potential clients denied access to payment processing services provided by the financial institution or any subsidiaries through a politicized or unlawful debanking action with the same violations, right? So you will go and you will make lists for us of all the people you screwed over on this basis, and then we will do something about it after the fact. But again, these banks aren't otherwise going to be bound to find that there was a violation of this type. The president can't order them to find a violation. He can only kind of tell his regulators what he's looking for, and the regulators can go and communicate that, and they can certainly press on some of these banks if they feel they're being untruthful on these questions. But it is an attenuated process that doesn't necessarily lead to anything at this point in time. Section 5, scrutinizing politicized or unlawful debanking. Within 180 days of the date of this order, the Secretary of the Treasury, in consultation with the Assistant to the President for Economic Policy, shall develop a comprehensive strategy for further measures to combat politicized or unlawful debanking activities of financial regulators and financial institutions across the federal government, including consideration of legislative or regulatory options to eliminate such debanking. Legislative options there being, including seeing if Congress is willing to pass a law on this. Regulatory options would be changing rules within our in-house executive branch offices, which can, of course, play a major factor in how banks actually operate because they are fully regulated institutions in the United States. But this is where the actual rubber hits the road. We're going to see if we need to do something more significant than this. This is the first step of potentially many, or potentially the last step of no further steps on this particular topic. And so the executive order should not be seen as screwing or destroying anyone. And I know YouTubers and influencers and commenters are used to kind of making headlines like that. But my job here, as I see it, is to tell you what the truth of the matter that I can see in these stories actually is. And in this particular story, this executive order is perhaps the weakest starting point that you can have for this, but you can still celebrate the win if you are so inclined, as the federal government in the United States actually being concerned about these kinds of things. But we have no indication that they are concerned about the things that we're concerned about with respect to video games and media and the payment processors throwing their weight around on that score as it stands this minute. Within 120 days of the date of this order, each federal banking regulator shall conduct a review to identify financial institutions subject to its jurisdiction that have had any past or current, formal or informal, policies or practices that require, encourage, or otherwise influence such financial institution to engage in politicized or unlawful debanking and to take appropriate remedial action to the extent authorized and consistent with applicable law, including levying fines, issuing consent decrees, or imposing other disciplinary measures against any financial institution subject to the jurisdiction of such banking regulator that they were engaged in this unlawful activity, including reference to Section 5 of the Federal Trade Commission Act, Section 1031 of the Consumer Financial Protection Act, and the Equal Credit Opportunity Act. So here he points to laws, right? And this is important because, as I said earlier, they are not the final arbiter of when a law has been violated. So we have to look at a few things. First, we'll look at Section 7A of the SBA, or more particularly how the SBA describes its 7A obligations, so that we just understand what we're talking about with respect to those SBA obligations. The 7A loan program is the Small Business Administration's primary business loan program for providing financial assistance to small businesses. But the SBA doesn't loan out the money directly. Instead, what the 7A loan program is the federal government guaranteeing repayment of loans to lenders. So you go to your bank, you're a small business, you say, I need $5 million. And the bank says, well, based on what you've got in place, that doesn't make any sense to us. You're too high of a risk. And the federal government goes and subsidizes these lenders. They guarantee the repayment of these loans to those lenders if they qualify under certain application type documents for purposes of an SBA guarantee. And this is one of those things that I do a lot in my line of work. I have a lot of small businesses. I have a lot of founders that are looking for capital. And the SBA loan program determines exactly how you are going to go and file for a loan with your local bank. And this is one of those things where the SBA has a major part to play in the economy of small business in the United States. But they don't actually give out the money themselves. They simply guarantee the repayments to the financial institutions. The maximum loan amount for a 7A loan is $5 million. Key eligibility factors are based on what the business does to receive its income, its credit history, and where the business operates. But importantly, as I just mentioned, they don't provide the loans directly, although they can help with the process because they're the ones that put the rules in place. So that's a 7A loan. You can see how the executive branch says, all right, SBA, Go tell the banks that you've otherwise guaranteed that they have to be in compliance with this executive order if they want to continue to work with the USBA. That's how an executive order works. Going a little bit further, let's talk about the FTC, because one of the things that was just called out was Section 5 of the Federal Trade Commission Act. This document here is a Congressional Research Service document that is designed to be given to Congress people to inform them of what's happening in various aspects of the law. This was done about the FTC in Section 5. It says, in addition to enforcing several specific laws, the agency enforces Section 5 of the Federal Trade Commission Act against all U.S. persons, partnerships, and corporations, subject to a few exceptions. Section 5 identifies two categories of acts under FTC's enforcement authority: unfair or deceptive acts or practices in or affecting commerce, and unfair methods of competition. The first of these provisions, frequently referred to as the UDAP provision, provides the basis for many of the FTC's consumer protection actions when the agency lacks more specific statutory authority. Section 5 does not, and this is important, define unfair or deceptive acts or practices. So the Federal Trade Commission, most recently in respect of non-competition agreements in the United States, can go and say, we think that this particular behavior of business in the country is unfair or deceptive. And then they can go and issue guidance on that. They can even bring enforcement actions, lawsuits against people they think violate their rules. The agency, as described here in this Congressional Research Service document, said they may issue policy statements or guidance. They may issue rules defining practices as UDAPs. The agency may pursue enforcement actions, as I just mentioned. But, again, importantly, when we're talking about Section 5, although they will assert, as they did in November of 2022, that they have broad authority to name anything like non-competition agreements as unfair or deceptive, we will find, as we look further in these stories, that they run into trouble when they do so. Federal court issues nationwide injunction blocking FTC non-compete ban. And this is as of August of 2024. This whole concept is still proceeding through the courts. But as we saw earlier in Virtual Legality with respect to Microsoft and Activision, the FTC or any other agency of the United States can say you're in violation of the law, but they aren't the ones that finally get to decide that. That is the court system. And so when the executive goes and tells his agencies that they should consider whether or not a debanking action would violate Section 5 of the Federal Trade Commission Act, then they can make that determination, but they're still not over the hump, out of the woods, in terms of actually winning that case in a court of law in the United States. So we're still many steps removed, many steps attenuated from actually saying, Visa and MasterCard, it's time to shake in your boots on any of this. Within 180 days of the date of this order, the federal banking regulators shall review their current supervisory and complaint data to identify any financial institution that is engaged in unlawful debanking on the basis of religion. And then they'll find that if they are unable to obtain compliance within the meaning of this specific act under the United States Code, a different law, they will refer the matter to the Attorney General for appropriate civil action. General provisions: the authority granted by law to an executive department or agency has not otherwise been impaired. This order is not intended to and does not create any right or benefit, substantive or procedural, enforceable at law or in equity by any party against the United States, meaning that if you feel like somebody isn't doing what they're supposed to do, that a bank is not reporting properly exactly what things they did that were illegal to the executive branch agencies that they are supposed to under this executive order, that you, as a person, a citizen of the United States, do not have the right to sue over this. This has not created some kind of contractual arrangement that can be breached by some party to this not doing what they're supposed to do. And then I highlighted at the end that as a bit of a slam or stray towards the Small Business Administration, the cost for publication of this order shall be borne by them, the SBA. And so what we see here is an executive order that is written as executive orders really must be, telling the agencies within the executive branch how the executive, the President of the United States, would like the laws to be enforced. But we don't actually see a lot of specifics around that enforcement. We see a lot of holes, a lot of loopholes by which a financial institution on the first part and a regulator on the second part could avoid doing much of anything under these particular rules. And so when people say that they're destroyed, when people say that they're screwed, I just want to caution folks from jumping in too heavily on that particular side of the argument, because there are a whole lot of reasons why, if I were the lawyer for MasterCard sitting in the MasterCard boardroom, I would say, all right, we have to see how this plays out. It certainly isn't nothing that the federal government is concerned about these things, but I would not be quaking in my boots, and I would explain all of this to them that, look, here is a point of weakness that the regulators have to actually abide by what the president wants to do here. Here's a point of weakness that the financial institutions actually have to believe that they violated something that they report to the regulators. Here's a point of weakness that any of this relates at all to what we're doing with respect to Steam and Itch, insofar as we're not making political statements. We're not trying to isolate the people that are in favor of the right or MAGA or anything else. We're really just aimed directly at the porn games that apparently offend us as an institution or otherwise. And so you're going to have a hard case to make if you want to tell us that we can't otherwise say, Steam, we don't want to be in the business of selling those games, and so we're not going to payment process for you. So if you are concerned about this story, what I would say is absolutely be concerned about this story, but remember that the executive orders are only for the executive branch, that this order is not aimed at the game situation, and that the vagueness and lack of laws on this make the effort as it stands at this moment in time a weak one. Now, there might be laws passed in the future. There might be something that makes this a stronger effort by the U.S. federal government. But as it stands right now, if I'm MasterCard, if I'm Visa, I'm saying, all right, I will take that situation under advisement, but I'm not super worried that my entire business model has been destroyed by the pen of the executive order. And that's been Virtual Legality for today. If you enjoy this content, as I said, please do consider supporting us on Patreon or through memberships and super chats on the channel, telling your friends that we're having these conversations, or just leaving comments, and more comments to this type of video, because that seems to be what YouTube likes the most right now. And on that note, I will leave you on one last comment from me, which is to say, as we've discussed earlier in this video series, one of the reasons I am so against what Steam has done in this particular context is that they have, in fact, negotiated with the terrorists. That MasterCard threatened to remove their ability to payment process, or Visa did, or PayPal, or whomever was actually behind the scenes on this. Steam capitulated, and as I said in that very first video in this series, capitulating to those demands, those terroristic demands, to prevent you from selling what it is that you want to sell to the buyers that want to buy it that are otherwise legal in the jurisdiction in which you're operating, leads to more requests from more terrorists. And this brings up a story that I've seen recently that says that Valve, the operators of Steam, says PayPal support is no longer available in some regions due to those content concerns that we have discussed. So this is why I get so frustrated as a corporate lawyer with the Steams of the world, even more than Itch, because I don't think Itch had quite the leverage that Steam did, because this was always going to happen. This was always the next step. If you capitulate on these grounds, if you just say, okay, yes, this kind of broad-based pressure is going to prevent us from selling what it is we would otherwise want to sell in our own market, then you're going to get more people asking more things, and there is no reasonable way to limit what has happened in this story to only the things that you find bad and to only the things that you would otherwise not want to buy for yourself. That's what I'll leave you with for this episode of Virtual Legality. I wish it were a happier note. I do think it's a good thing that the government overall is looking at these issues and saying that's something that maybe we should address. But an executive order basically never answers the question from a legal point of view. And in this particular case, it even answers less than it might otherwise do in other contexts. Thank you so much for being here with me, and I will catch you on the next episode of Virtual Legality or otherwise.
Virtual Legality is a YouTube video series with audio podcast versions presented as commentary and for education and entertainment purposes only. It does not constitute legal advice and does not create an attorney-client relationship. If you have legal questions about the topics discussed, please consult your own legal counsel.